Hello and welcome everybody. Thank you for being here. My name is Claret Vargas. I'm the Executive Director of the Stanford Human Rights Center, and I am delighted to welcome Professor James Anaya to Stanford. Let me first gratefully acknowledge the co-sponsorship of the Center for Latin American Studies. I see that Elizabeth Sands-Ackerman, its Associate Director, is here. Thank you so much. I also want to thank the Native American Cultural Center and the Native American Law Students Association for their co-sponsorship. Thank you, and thank you for being here. Professor Anaya is the United Nations Special Rapporteur on the Rights of Indigenous People, as all or most of you know. He's also Regents Professor and James J. Lenoir Professor of Human Rights and Policy at the University of Arizona, James E. Rogers College of Law. He served on the law faculty at the University of Iowa from 1988 to 1999, and he has been a visiting professor at Harvard Law School, the University of Toronto, and the University of Tulsa. Professor Anaya's contributions to the field of Indigenous peoples' rights and international law are really too long to list, but they include over 36 articles and book chapters, several books, and numerous reports written as the UN Special Rapporteur. His book, Indigenous Peoples and International Law, first published in 1996 and then in a second edition in 2004, is widely recognized as an essential work for anybody working on the rights of Indigenous peoples from an international norms perspective. I don't think it's often that the reviews of a book almost unanimously announce it to be a required reading in your field, but this is the impact that this book had. In addition to his scholarly work, Professor Anaya has also played a key role in developing the international standards related to Indigenous peoples' rights. He participated in the drafting of the United Nations Declaration on the Rights of Indigenous Peoples, which was adopted in 2007. He contributed to the development of the jurisprudence of the Inter-American system as lead counsel in the landmark Awastingi case, a case before the Inter-American Court of Human Rights, where the court, for the first time, upheld the right of Indigenous communities to their collective land as a basic human right and as a matter of international law. This ruling was binding. Prior to becoming a full-time law professor, he practiced law in Albuquerque, New Mexico, representing Native American peoples and other minority groups. For his work during that period, Barrister Magazine, a national publication of the American Bar Association, named him as one of the 20 young lawyers who make a difference. Throughout his career, Professor Anaya has done what we at the Human Rights Center applaud and really hope to encourage. He has combined direct advocacy and scholarship in a seamless and productive and deeply impactful way. We are honored to have him here today. Please join me in welcoming him to Stanford.
Thank you, Claret, for that kind introduction. It's really great to be here. I want to thank the Center for Human Rights for inviting me here to share some thoughts and to interact in some, what I'm sure will be some very interesting dialogue with you. And also want to acknowledge the other co-sponsors of today's events. What I want to discuss today are the dominant trends, what I see as dominant trends of strategy and action within the international human rights movement, and the need for redirection of these trends or energies to develop and prioritize new trends. What do we mean by the international human rights movement? Well, the international human rights movement is a network of individuals, academics, institutions like the Center for Human Rights, state actors, as well as multiple others that are engaged in a move toward the consolidation of global standards of human rights and the effort to promote the application of these standards through means that transcend national boundaries. We can see this movement in the modern sense, dating back to at least the anti-slavery movement of the 19th century and blossoming post-UN Charter in the 1940s and continuing on today to take on ever more importance as a matter of international law and relations. Within this movement, we can see what I would identify as four major trends in the definition of strategies and courses of action. One is the push toward new international instruments in the form of declarations or treaties to be ratified by states that affirm human rights that is the articulation of human rights norms and their incorporation into written instruments. And this trend really got off the ground, as did the human rights movement, with the affirmation of the Universal Declaration of Human Rights in 1945, and then subsequent to that, the other documents that form the International Bill of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, Cultural Rights, and with that, a multitude of other documents that advocates pressed for, and that as time has passed have focused on ever narrower areas of human rights concern. And these areas of concern today include the right not to be tortured, and we're honored to have here this former Special Rapporteur on that right not to be tortured. It's not the Special Rapporteur on torture, is it? I mean, well, it's not quite on torture, it's against torture with us. And accompanying that institution, of course, is a treaty and a declaration, and also declarations, treaties on rights of women, children, minorities, indigenous peoples, migrants, persons with disabilities, and so on. Really a proliferation of different international instruments have been driven by the international human rights movement, both at the global level and at the regional level. Well over 200 declarations and multilateral treaties, by my count, and perhaps more, have been developed, especially if one counts the declarations and treaties that have come out of not just the UN proper, but the specialized agencies of the United Nations, like the International Labor Organizations, with this multitude of treaties aimed at labor issues, and also the documents coming out of the World Health Organization and UNESCO in the area of culture and discrimination, or the right not to be discriminated against. Then, of course, at the regional level, we've seen the human rights movement result in a number of documents in the Americas: the American Declaration, the Rights and Duties of Man, the same vintage as the Universal Declaration, adopted in 1948, the American Convention on Human Rights, and then a number of convention aimed at special areas of concerns like eradicating violence against women, social, economic, cultural rights, most recently the rights of persons with disabilities, a treaty that was developed and proclaimed by the Organization of American States, and open to ratification. In Africa, the African Charter on Human People's Rights, and new treaties or declarations on children's rights, women, refugees. In the Asian region, we've seen interesting developments. The ASEAN, or Association of Southeast Asian Nations, Human Rights Declaration was adopted in 2012, really opening the door or catapulting that region, or furthering the discourse in that region toward ever greater attention to human rights concerns. Then, of course, at the European level, the European Convention on the Protection of Human Rights and Fundamental Freedoms. So really a proliferation of international human rights instruments that the international human rights movement has pressed for, and the movement we can see continuing to press. So we can see different actors within the movement, NGOs and some state actors, pushing for even more and new additional human rights instruments. And a lot of energy devoted toward that still. A second trend, it involves the push toward more international institutions, the creation of new international institutions that are capable of receiving and somehow pronouncing upon complaints of human rights violations. That is, that are capable of reviewing state action and the action of others who may infringe human rights, and pronouncing on violations. And we've seen develop, as a result of this movement, ever more institutions and procedures within the UN and regional systems to address human rights concerns, and particularly to pronounce upon and make recommendations upon, and sometimes binding, or what are considered to be and formally are binding decisions upon human rights complaints. Within the UN system, of course, we have the so-called treaty monitoring bodies that are connected to the major UN treaties, including the Human Rights Committee, the Committee on Economic, Social, Cultural Rights, CEDAW, the Committee on Elimination of Discrimination Against Women, 9 of them connected with the major human rights treaties that one way or another have the capacity to receive information and pronounce upon human rights situations. And we see these treaty monitoring bodies proliferating over the years, so that what started with just a couple of them, the Human Rights Committee and the Committee on Economic, Social, Cultural Rights, now we have 9 of them. There's the Human Rights Council, of course, which is the intergovernmental institution of the United Nations, made up of 47 member states who have taken on the task under the UN Charter of promoting human rights throughout the world. And the Human Rights Council has established its system of so-called special procedures, which include the system of special rapporteurs, including the special rapporteur against torture and the position I hold, which is the mandate of the special rapporteur on the rights of indigenous peoples. And what started out with just a few of these special procedures mandates now has resulted in a number of them as the result of the human rights movement pressing for ever more institutions and mechanisms to address human rights concerns. And so now we have 37 what are called thematic mandates, that is, mandates or special rapporteurs or other independent experts aimed at particular areas of concern like torture, rights of indigenous peoples, minorities, violence against women, and so forth, housing, food, a proliferation of them. Every year, for the past several years, the Human Rights Council has created a new one as a result of the human rights movement, or elements within it, proposing ever newer and more mechanisms, institutions to address human rights concerns. Then these are just a few of the institutions that exist within the UN system. There's the Secretariat itself, which has the capacity to review in some way or another complaints of human rights violations and pronounce on them in one way or another. Then specialized agencies like the International Labor Organization Committee of Experts, which receives complaints, communications, information about human rights conditions and pronounces them. At the regional level, as we know, the Inter-American Commission on Human Rights and the director of the Human Rights Center, James Cavallaro, is now a member of the Inter-American Commission of Human Rights, a body of 7 independent experts, and along with the Inter-American Commission at the regional levels, the Inter-American Court of Human Rights, also a 7-member body, but made up of judges with the capacity to issue legally binding decisions within their sphere of jurisdiction, which has to do with, which is essentially optional for states. And also at the regional level, the African Commission on Human Rights, Human and People's Rights, which is similar to the Inter-American Commission, and now an African Court on Human Rights, the European level, the European Court on Human Rights, and at the Asian level, now an ASEAN, that is Association of Southeast Asian Nations, Intergovernmental Commission on Human Rights that has just got its work off the ground. So we can see that the international human rights movement has resulted in a number, and one might say a proliferation of these international institutions. A third trend, and related to the second one, is the ever greater use or the increasing use by advocates of these institutions to review state behavior and have them address complaints of human rights abuses. We can see, if we look at the activity of any one of these institutions, we can see them ever more responding to complaints submitted by non-government organizations and individuals about human rights abuses or alleged human rights abuses. So we can see a phenomenon by which within the movement ever more individuals and non-government organizations are appealing to these bodies, seeing them as potentially effective in addressing the human rights concerns that they raise to these bodies. And a fourth element, a fourth trend within the human rights movement that can be identified, and I'm talking about the dominant trends, is the promotion of studies to examine one or several of the multiple dimensions of issues, including that fall within the rubric of human rights. And these include studies by international institutions. And so we see really a proliferation of studies done by all of the institutions that I've mentioned, plus many more, hundreds, thousands, really, of these studies on areas of human rights concerns. And this has been a key objective of the human rights movement, is to press for studies on one matter or another. And these studies feed into the argument for new international institutions, the arguments for new treaties or new international instruments, and arguments for ever greater proliferation of an international system capable of addressing human rights concerns through multiple means. Now, undoubtedly, the strategies around these trends have had a positive impact in terms of raising awareness about human rights on a global level, consolidating or building consensus about the standards of human rights, identifying particular problems, areas of concern that need attention, and prodding states toward action, states and other actors towards action to correct human rights problems, and to create more of a culture of human rights, both at the domestic level and internationally, in which human rights violations are less likely. I think we can see the international human rights movement in the modern sense of the movement, especially since since the creation of the United Nations, since the adoption of the Universal Declaration in 1948. We can see the international human rights movement having positive effects in this respect. But nonetheless, I think we need to reflect upon today to what extent, on the question of to what extent should strategies in action now continue along these trends, given contemporary conditions and the fact that we do have in place already a range of human rights instruments and institutions. And we have a body of experience now upon which to draw. And we have understandings now that have been developed by many about the character of the international system more generally and its relation to human rights in particular, from which to draw. I think the answer to this question really depends upon the context. And again, the question, let me just specify what I mean by this question of the extent to which strategies and action should now continue to along these trends. It involves the question of to what extent should human rights advocates continue to prioritize developing new international instruments or new institutions, or prioritize putting more and more effort into using those international institutions to complain about human rights abuses, or promoting new studies about human rights problems on a global scale when we have already thousands of studies. To what extent should these strategies around these trends be prioritized? And again, I think the answer will depend upon the particular context and on the particular human rights issues that are at hand. But at least in many contexts, I think that it's time to be rethinking the effectiveness of these strategies for today, and to be thinking about developing and giving priority to other strategies that will lead to a new or fresh set of strategies within a fresh set of trends. Now, what I'd like to do is examine, again, this question in the particular context of indigenous peoples, of course, an area that I'm familiar with, that I have a good deal of experience with, and I'm now working, an issue that I'm working closely with in my capacity as UN Special Rapporteur on the Rights of Indigenous Peoples. Now, the human rights movement as it relates to indigenous peoples had, in fact, as its initial focus, the development of a new instrument or set of instruments to affirm indigenous peoples' human rights. The indigenous human rights movement, or the movement as it concerns indigenous peoples, can be seen getting off the ground in the 1970s when indigenous peoples themselves traveled to the UN headquarters in Geneva, which is which has developed into the headquarters of the human rights machinery of the United Nations system. And it appealed to the elements of the United Nations system that concern human rights to address their particular concerns. And a premise of their arguments or their pleas to the United Nations was that existing instruments do not adequately address their concerns or incorporate protections for their particular rights as peoples. And those rights, indigenous peoples found, were rights that in one way or another were already affirmed within human rights instruments, like the right to culture, the right to self-determination, but were not sufficiently contextualized in relation to their particular realities. And so what indigenous peoples were capable of doing over a period of years was articulating to the world their rights in terms of their collective rights as peoples, arguing them in terms of basic human rights standards, and ultimately achieving recognition of those rights in the form, most prominently today, of a Declaration on the Rights of Indigenous Peoples that was adopted by the UN General Assembly in 2007. Also worth mentioning is International Labor Organization Convention number 169, a multilateral convention that has been ratified by almost all countries in the Americas and a smattering of countries elsewhere, that affirms indigenous peoples' rights and sets forth a number of standards in terms similar to, although not as far-reaching as those in the Declaration. The convention, of course, being binding as to those states that have ratified it. And so the creation of these two instruments and the adoption of these two instruments has been a result of the indigenous rights movement, consistent with the trends of the international human rights movement more generally. Also, the movement as it concerns indigenous peoples has pressed for new institutions specifically focused on indigenous peoples' concerns. And of course, these are developed ultimately in the form of, one, the Permanent Forum on Indigenous Issues, which is an expert body linked to the Economic and Social Council, made up of 16 independent people appointed by the Economic and Social Council, the president of the Economic and Social Council. Also, the mandate, the institution of the Special Rapporteur on the Rights of Indigenous Peoples, which was created around the same time as the Permanent Forum was created as one of the special procedures of the Human Rights Council, with a mandate to examine concerns of indigenous peoples around the world. The Permanent Forum's mandate is more to advise the UN system, at least the explicit terms of its mandate by the General Assembly and the Economic Social Council are to advise the UN system. So it develops studies, it addresses particular programs within the system, and tries to promote greater attention within the UN system about indigenous people's concerns, whereas the mandate of the Special Rapporteur is to address particular cases of human rights concern, including violations. A third mechanism, a third institution pressed for by indigenous peoples that ultimately was developed is the expert mechanism on the rights of indigenous peoples. And this was established in 2007, the same year, in fact, that the Declaration on the Rights of Indigenous Peoples was developed. And this is a subsidiary body or a body, an expert body attached to the Human Rights Council. It's not properly one of the special procedures, that is, special rapporteurs or independent experts that have the mandate to examine particular human rights concerns in country situations. This is a different kind of body with a mandate to engage in studies, research-based studies about indigenous people's concern. So this feeds into that strategy of developing studies that trend towards more and more studies. Now, at the same time, indigenous peoples were pressing for new standards or new instruments and pressing for new institutions to address their concerns. They began using existing international institutions. And so we saw, beginning in the 1980s in particular, indigenous peoples and their advocates going to, say, the Human Rights Committee to press claims alleging violations of the right to self-determination of Article 1 of the International Covenant on Civil Rights, or the right to culture under Article 27 of that same instrument, or other provisions of the International Covenant on Civil and Political Rights. We had a series of cases before the Inter-American Commission on Human Rights, the one that I was involved in, the one that reached the Inter-American Court ultimately. As you know, cases that go before the Inter-American system first go before the Commission, then go before the Court. We initiated the case before the Inter-American Commission in the Agustini case in 1994. It eventually, or 93, sorry, reached the Court in 97 and ultimately was decided by the Court in 2001. And with these and several other complaints before international institutions, we saw developing a body of jurisprudence by these institutions that, one, linked indigenous people's claims and assertions of their rights to existing human rights standards, thus helping to clarify what existing human rights standards of general applicability, standards such as the right to culture, non-discrimination, self-determination, and so forth, clarifying how these grounded the more particular rights being asserted by indigenous peoples, their rights to their own language within the ambit of the right to culture, for example, their right to their own lands and resources according to their own traditions within the ambit of the universal right to property and right together with the right to culture, their particular rights to self-government or some form of autonomy within the ambit of the right to self-determination. The body of jurisprudence helped to clarify or helped to establish that these more particular rights that indigenous peoples were claiming were connected with these human rights postulates or human rights norms of general applicability, and in turn then help to animate or catalyze the process toward developing a new human rights instruments in the form of eventually a declaration on the rights of indigenous peoples. And then the movement, of course, has involved pressing for more and more studies. And I already mentioned the studies that have come out of the expert mechanism of the rights of indigenous peoples that continue to come out We can also mention the studies that came out of, or coming out of the Permanent Forum on Indigenous issues. We're talking upwards of probably, if not 100, or close to 100 studies that Permanent Forum on Indigenous issues has developed on various areas of concern to Indigenous peoples. Recently, a study on the doctrine of discovery, this doctrine of 16th century by which Europeans purported to gain title to lands that they simply happened upon or discovered, notwithstanding the presence of others, as long as the others could be considered savages and not of the same level of civilization. A study on that, a study on Indigenous peoples in the Arctic and the effects of climate change, and a study on extractive industries and Indigenous peoples, or the duty of states to protect Indigenous peoples against the negative effects of extraction. A range of studies of these kinds, like I said, upwards of 100. And so we've seen the movement, the Indigenous rights movement, continue these same strategies. Yet, despite the success that Indigenous people have to some degree within these strategies, achieving a declaration, achieving new institutions, winning cases, having more and more studies, we still see Indigenous peoples across the globe suffering human rights abuses. We still see Indigenous peoples uniformly disadvantaged vis-a-vis the broader populations in the countries within which they live. They still suffer from acts of discrimination and acts of violence. So there's a need to reflect, as there is with regard to the human rights movement more generally, about continuing these same strategies or doing something else, if only something slightly different. Now, with regard to the Indigenous rights movement, what we've seen is that in some respects, Indigenous peoples have continued to do the same. In other respects, not necessarily the case. With regard to the promotion or the development of new international institutions, what we've seen, particularly recently, is, for the most part, Indigenous peoples pull back from initiatives to develop ever more human rights instruments that concern them. There was, and still is, in fact, afoot, an effort for the development of a declaration on the rights of Indigenous peoples at the American regional level. So there was, in fact, at the same time, there were efforts to develop a UN declaration, which were ultimately successful. There were efforts to develop an American declaration on the rights of Indigenous peoples. Those have stalled, and we've seen Indigenous peoples not put as much, and their advocates not put as much effort into that initiative. There's also, at some point, talk about moving beyond simply a declaration of the rights of Indigenous peoples and developing a convention, a treaty, multilateral treaty that would be binding for states on Indigenous peoples' rights, coming out of the United Nations system that would be parallel to or exist alongside the Declaration of the Rights of Indigenous Peoples and the ILO Convention on the Rights of Indigenous Peoples. And we see initiatives by Indigenous peoples to develop standards on intellectual property and traditional knowledge within the context of ongoing proceedings of the World Intellectual Property Organizations, as well as initiatives to insert their concerns within processes having to do with climate change. And so a number of the documents that have developed around climate change have included provisions on Indigenous peoples. But for the most part, the international human rights movement, as it concerns Indigenous peoples, has been focusing on shoring up support for the existing instruments, and particularly for the Declaration on the Rights of Indigenous Peoples, consolidating awareness of that instrument and support for us. And it's focused on seeing the norms in the Declaration and other existing instruments implemented. So not so much the developing of new international treaties, but in seeing the norms that are articulated in already existing instruments implemented. Now, what's happening, I think, is that Indigenous peoples are coming to terms with the limitations of the international system, which is a system, as we know, of states. And those limitations involve the fact that states typically are very reluctant to develop instruments, and much less agree to them, to be bound to them, when those instruments include standards that go beyond what their domestic law includes or what states are prepared to enact within their domestic law. And so Indigenous peoples are seeing that they have reached, and their advocates have seen that they've reached sort of that point in which further particularity around standards is pressing states to do more than they're prepared to do. It's not that states don't respond in those terms, but that's effectively, I think, what's happening. They're being pressed. If indigenous people, to the extent indigenous peoples have pushed for more instruments and further standards, those are pressed up against what states already have in their domestic law or are willing to enact in their domestic law. And this brings forth a lot of questions about what we're doing within the international system when we're advocating for new international instruments. Of course, we're trying to raise the bar. We're trying to establish standards that go beyond what states are doing. But there are necessarily limitations of that, given the very nature of the system and the nature of state power within that system. So indigenous peoples, like I said, are now mostly, and their advocates mostly focused on shoring up support for existing instruments and seeing the norms in those instruments implemented. But the focus on implementation has really substantially followed the second of the dominant trends I've mentioned. That is the effort to have new institutions created. So now in the preparations for the upcoming World Conference on Indigenous Peoples, which the General Assembly is going to hold in 2014, within that framework, Indigenous peoples and their advocates are developing a number of proposals. And prominent among those proposals are proposals for new institutions and procedures. So Indigenous peoples are proposing a new complaint procedure connected with a new institution in order to hear and pronounce the complaints of violations of the UN Declaration on the Rights of Indigenous Peoples. Another proposal is to have a body specifically constituted to hear complaints about violations of treaties between states and indigenous peoples, like the historical treaties we have in the United States between many Indian tribes and the United States or its European predecessors. Another proposal is for yet another special rapporteur on violence against indigenous women. And that, of course, would be in addition to the special rapporteur on rights of indigenous peoples and in addition to the special rapporteur on violence against women generally. And along these same lines, indigenous advocates are pressing for ever greater means of participation within existing institutions, even claiming some greater access to and means of participation within General Assembly processes, and the General Assembly, as you know, is the major body of the UN made up of independent states. And there are very limited means of participation in the General Assembly proceedings by non-state actors. And at the same time that the movement is pressing for new institutions, we're seeing an increasing use of existing international institutions. So that since the Awastini judgment and case, we've seen a growing, really exponentially growing number of cases being put to the Inter-American system, both to the Inter-American Commission on Human Rights and the American Court concerning indigenous peoples' concerns. And many of those cases are being decided favorably to the indigenous claimants, or those claiming on behalf of indigenous peoples. So we see a growing number of petitions being submitted to the UN treaty bodies, the Human Rights Committee. The Committee on the Elimination of Racial Discrimination receives numerous complaints every year around indigenous people's concerns. Growing complaints to existing bodies connected with the International Labor Organization in connection with ILO Convention number 169. And again, within these various bodies, many favorable decisions. And then also, along the fourth trend, that of new studies, ever more requests for more and more studies. And so, one goes to the Permanent Forum on Indigenous Issues, you see one of the biggest areas of proposals that are made by indigenous participants and their advocates are proposals for more and more studies on ever more narrow issues, or studies to follow up on a previous study. So a lot of studies, a lot of complaining, a lot of decisions. So a continuation, if not the first trend, of the strategies within the first trend, certainly a continuation of action along these other three. That is the creation of new institutions, the ever-increasing use of existing mechanisms to adjudicate complaints or to make complaints, and the press for ever more studies. And what we're seeing with this, I think, is a high level of faith in the international system to have or to develop institutions and procedures that are capable of effectively implementing state-endorsed international standards. A lot of faith in these institutions or in the system to create or have mechanisms that can effectively implement standards of human rights. And even when there's frustration in the lack of effectiveness of these existing international procedures. Now, I said indigenous peoples have been effective in getting positive decisions, but that hasn't necessarily translated into application of those decisions by these institutions on the ground. In fact, with regard to all of the cases that have gone to the Inter-American Court of Human Rights concerning indigenous peoples' concerns, only 2 have really been implemented. One, the Awastini case, and that, like Claret said, before I was rapporteur, I was the lawyer for the Awastini community. That judgment came down in 2001. It wasn't until 2008 until there was a favorable decision. And another case out of Paraguay, there was a favorable. The others still haven't been implemented. So it took us 8 years in the Awastini case, or almost 8 years, and most of the others still haven't been implemented. So, and the same can be said of many other decisions, and even if only in the form of recommendations by other institutions within the international system. They simply haven't translated to change on the ground. And there's a lot of frustration about that. But that frustration then translates into the proposal for more institutions, as opposed to something different. Okay, create a new institution. So a lot of faith in the international system's capacity to affect change in one way or another. And I think that this faith is really overblown. Myself being part of the institutional framework of the international system, at least for the next few months. I think it miscalculates the way in which international norms and processes linked with international institutions may most effectively influence behavior. International institutions, in a formal sense, I think, can bring problems to light, but really only bring problems to light, or for the most part only bring problems to light. And even those with binding decision-making authority can rarely, by themselves, effectively command states to do something that they're not already prepared to do, even those with binding authority. We can look again to the binding decisions of the Inter-American Court of Human Rights. It's hard, if not impossible, for states to yield decision-making authority to supranational actors, to cede effectively sovereignty, their decision-making authority with regard to matters within their domain of sovereignty. It's hard for them to yield that decision-making authority to international actors or to allow supranational actors to trump state decision-makers, particularly, again, over local matters. And there are a number of cases that we could point to with regard to this. Cases in the United States concerning the Western Shoshone people that have gone to the American Commission on Human Rights, the Commission pronouncing violations by the United States of the human rights of the Western Shoshone people in the United States. Okay, we heard you, fine, we disagree, and that's it. In Belize, a weaker country, doesn't have the same powers as the United States internationally. You would think couldn't withstand international criticism as much, the same thing. Very strong decisions by the American Commission on Human Rights declaring violations of the rights of the Maya people to their traditional lands. Government simply ignoring those decisions. And even after the communities, the Maya communities have gone back repeatedly to the Commission and gotten reaffirmation of previous decisions. The Saramacca case by the American Court of Human Rights, a very important judgment by the court establishing the duty of states to consult within the context of the American Convention on Human Rights, and finding Suriname in violation of the right of the Saramacca people to the lands and resources by virtue of having granted logging concessions to those lands. That was in 2005. Nothing, no action to implement that decision. I even, in my capacity as special rapporteur, went there in coordination with the Inter-American Commission and the court to discuss with the government. And I met with the cabinet and the president about implementing this. They were very nice to me. We had really nice meals, but that was it. And so we see this reluctance on the part of states to take action to follow the command of an international institution with regard to action they're already prepared to do. I think we need to come to a greater understanding about how international institutions can best have an effect and how states interact with international institutions. I think that international institutions operate most effectively when they ignite domestic processes within states that themselves lead to effective application of international human rights, or when those international decisions and processes are linked to inducements, either at the domestic or at the international level, in other arenas, inducements like money from the World Bank that encourage states to see implications of international norms, the application of international norms in their best interest. And so, in fact, in the Awastini decision, one of the inducements we were able to draw upon was World Bank funding for Nicaragua to implement the Awastini decisions. In that case, we were also able to link up to domestic processes, political processes, that from within Nicaragua animated movement towards application of the Inter-American Court's decision. Harold Koh, whom I believe you all know, I think he was here recently, has described the process of how what he calls states obey international law to be one of norm internalization, one in which states are not coerced into international action, but rather one in which norms and decisions are incorporated into states' internal normative and political processes. And so I think we have to keep that in mind when we think about strategies of implementing human rights standards or promoting the enjoyment of human rights more broadly. And so what kind of strategies should now be given priority? Now, let me talk about this, and I want to wrap up here, so I want to leave some time for questions. But I want to talk about this in the context of yet another case that I've been involved in. This one in relation, a case I was involved in connection with my work as UN Special Rapporteur. It has to do with the proposal for the construction of a major hydroelectric dam in Costa Rica, El Diquis hydroelectric project. A dam that would, if built, would create a reservoir that would flood indigenous lands, indigenous territories. And I received information from Costa Rica, from the representatives, from non-government organizations and representatives of indigenous communities affected, complaining about this, saying how their rights weren't being respected and how they hadn't been consulted. And when I communicated with the Costa Rican government, the Costa Rican government invited me to go to the site to initiate a dialogue with all the actors concerned and to develop a report with recommendations around that situation. And what I found was that the government, the people within the government, were fairly readily willing to engage in consultations about the dam. In fact, they followed my recommendation to suspend construction of the dam until such consultations were engaged in. And the indigenous people, on the other hand, were not entirely opposed to the construction of the dam once they learned it wasn't going to flood all their lands, just a part of it, and that there were possibilities of them getting compensation, alternative land, and even otherwise benefiting, including through getting access to more electricity themselves. Okay, so both parties will engage in consultation, but how do you do that? What's the process? We saw that the leadership structure had been fractured over time because of government policies going back to years. We saw that there's confusion about the scope of the consultations. What was illustrated in this case was the need for technical cooperative assistance at the local level by non-governmental organizations, by the international system itself, to help establish a procedure for adequate consultations and carry that forward. Now, I recommended adequate consultations, and I put down the parameters, but there was nothing in place. None of the NGOs were around to help with the consultation. They were around to denounce the lack of consultation. They were around to go to the international institutions to denounce a lack and to try to get a decision. But when it came to doing what they were denouncing wasn't happening, they were around, or there wasn't the capacity among them to do it. The international system, the UN system. I recommended various agents of the UN to come in, the country team at the local level. Manfred, I don't know what your experience is with trying to get the country teams to actually follow your recommendations and move, but there was really no capacity to move forward with that. Nowhere within the system, but this is what was needed. So the need for technical cooperative assistance by the non-government organizations, intergovernmental organizations, and the donor community. We went to the government of Denmark, Norway, all of these that were giving money to Costa Rica for environmental programs, even for indigenous rights programs. But their efforts weren't geared in this direction. Related to the issue of lack of consultation, I found immediately that there were underlying concerns The land tenure situation of the communities was precarious. The boundaries of where their traditional lands extended was not sufficiently defined. Their lands had been invaded by outsiders. And like I said earlier, their leadership structure had been fractured by a series of developments over time, dating back to the time that the government simply didn't recognize their authorities and put in place individuals appointed by the government itself to administer indigenous communities. That had fractured the indigenous people's own leadership structure. So there were underlying systemic problems that needed to be addressed. It wasn't just the immediate concern about the dam and the effects of the dam on their lands and human rights. There are underlying systemic effects that need to be concerned. So there needs to be attention to these underlying systemic concerns, but in a real way. And not just to develop a study about them, but then to go in and address them. In the case of Costa Rica, the Costa Rican legislature needed assistance in developing legislation and continues to need in how to recognize indigenous authority structures, legislation on how to effectively secure indigenous land rights and mechanisms to demarcate those lands and so forth. And there needed to be attention to how to deal with the people that had gone on to indigenous lands and settled there. And many of these people are poor peasants with difficulties of their own. And the answer simply isn't to just to remove them by force, at least in my estimation. Difficult, complex issues that needed to be addressed, but that weren't being addressed within these trends of the human rights movement, within the existing strategies and mechanisms being employed by the human rights movement. And then finally, with regard to this situation, I saw what I call the political invisibility of indigenous people. There's a big national debate happening about this dam. On the one hand, the government and the president saying this is a matter of strategic national interest because of our need for sustainable energy and clean energy. And remember, Costa Rica likes to pride itself as a very green country. At the same time, many among the green movement were saying, no, this isn't the kind of clean energy we need because of its effects on the environment, certain lowland areas where there are marshes, very fragile, and so forth. This was the debate. And in this national debate that one could see exhibited in the papers, reflected in the newspapers, and within the circles of the national legislature, indigenous peoples were simply, and their rights and concerns were simply invisible. That owes itself to the more general invisibility of indigenous peoples within societies. We see that in this country. You average American, certainly not anybody in this room, doesn't know about the presence of indigenous people in this country or what that presence implies for a certain segment of the population. I live in Tucson, Arizona, and I know that many of my students have no real sense about what the communities that surround us, the native communities that surround Tucson, what those communities are like, or what the conditions are of the people living there, or that the real contributions they make. That's a common phenomenon in this country, and it's a common phenomenon in countries worldwide. This invisibility of native peoples, not just invisibility about their concerns, about their ongoing human rights problems, but about their very presence and their contribution. And so what is needed here, I think, with regard to this, are strategies of education at multiple levels, from the level of preschool or primary education to the level of educating politicians and those in powers in positions of power in government or influence in industry. An education about human rights more generally, and in this case, indigenous peoples in particular. I see a great need for campaigns of education on human rights around multiple concerns. So, a shift that I'm advocating is towards more problem-solving oriented strategies aimed at instigating local decision-making to apply existing international human rights standards. And that will have the effect upon building upon those standards and strengthening them in turn. A strategy that includes technical cooperation at the local level to implement international human rights standards, a strategy that addresses systemic issues of human rights concern, and a strategy that helps to educate the general population as well, and particularly those in positions of power and influence. Let me conclude by saying that in my own work within the international human rights movement, I've tried to keep foremost in mind the ultimate objectives of any human rights work. And that ultimate objective, I think we can all acknowledge, is to see change for the better in the everyday lives of people, particularly the most vulnerable among us. So I think it's time to move beyond proclaiming standards of human rights and denouncing deviation from those standards. We already have, as we've seen, I think, an array of international declarations and treaties covering almost any imaginable human rights issue. Certainly there are some certain areas that still need to be addressed. But for the most part, they cover almost any imaginable human rights issue. And we already have a lot of attention by international institutions on these issues. And we can see that efforts to have them denounce or recognize human rights problems doesn't get us to implementation of the human rights standards or to resolving the problems in the way that we need them to be resolved ultimately. So I think it's time to put our focus on the international human rights standards that are already accepted in international instruments and to get down in earnest to the hard task of helping to make those standards operational at the local level, in a way that genuinely fixes human rights problems and makes their reoccurrence less likely into the future. So thank you. That's all I have, and I'm happy to take some questions.
To the microphones, if you have questions, please.
Thank you so much for that fine lecture. I'd like to ask you about one of the particularly emblematic cases that came before the Inter-American Commission on Human Rights, which was the Belo Monte Dam case. And in that case, the Brazilian government didn't just ignore the decision, they actually pushed back and threatened to cut funding for the commission. They lobbied other governments in South America to work against the commission. So my question is there also a backlash movement against human rights from these national governments? Not simply they're not recognizing it, they're actually pushing back in the other direction.
I would say that some governments in certain respects at certain times are trying to hold the line and are taking particular stands against what they see is the development of norms that they fundamentally don't agree with. And the Belo Monte Dam, I think, involves one of these scenarios where what advocates are proposing there is that any impact upon indigenous people be absolutely avoided. If one looks at the advocacy that was or is around the Belo Monte Dam, it really is focused on not just mitigating impacts by the creation of a dam that has presumably a social purpose behind it, but avoiding any impact whatsoever. And then secondly, allowing indigenous people what amounts to a veto power against it. Now, there are all kinds of arguments that can be made in favor of that norm or that proposition that indigenous people should be able to avoid any kind of impact on their lives and have effective veto power. But governments, including the Brazilian government, don't accept that, at least not yet. And I think more consistently with the way the international human rights architecture is today, say we need to have a balancing. We are going to mitigate the impacts, and in fact, they did alter the design of the Belo Monte Dam. I was in conversations with them, confidential at the time, but now I can talk about it. And they did present me detailed information on the alterations they had made. And in fact, whereas the dam was going to cause flooding of indigenous territories and the removal or displacement of indigenous peoples from their lands, the plans that were ultimately developed were altered to not make that happen. But there were going to be some impacts. There were going to be diminished river flow and potentially diminished fish stocks upon which some of the indigenous communities depended, and so forth. But the controversy came to be around whether or not there could be any impacts and whether or not the government could move forward without, while indigenous people or their advocates, I think one might say more precisely, were in strong opposition to this. Now, there was another thing that happened, and I think we can talk about this openly now as well, is that the commission really didn't consider these mitigations that the government had in place. I think it would admit now that I'll admit that it jumped the gun on its call for precautionary measures, and that's why, and this is not very much talked about, they altered their precautionary measures to simply say that the Brazilian government should not go forward with the dam, to ensure that the human rights of the indigenous peoples are protected in the context of the dam, as opposed to calling for its suspension. And that's what the commission did. So these are complex issues. And this is part of my point. How do we address these issues? By new international standards? Do we sit around the table and argue about right of informed consent and blah, blah, blah? Do we establish a new institution? Do we go back to the American Commission? Do you go back to a special rapporteur, like people are saying, yeah, I got to pronounce on the bill of multi-dam, go back to the commission, and everybody's, in the best circumstances, we say, address this concern, and the government comes back and says, look, it's more complicated than you know. Or do we develop another strategy, all of us, to say, okay, we're going to engage this issue on the ground, and we're going to do some problem solving. And part of that involves going beyond the classic vilification of governments, which is what we have in the movement today. If you sit down with the government, it's like, that's not what you're supposed to be doing as NAVIC. You're supposed to be opposing them. They're the enemy. The company's the same. And what I've learned as Special Rapporteur more and more is that, governments are like families. There's some good people in them, and there's some nasty people in them. And you got to deal with those good people in them and help them overcome the nastiness. And that, I think, is part of this more realistic problem-solving orientation that I'm arguing for. And I think what the bill of multi-dam scenario itself could benefit from strategies along those lines. And that is a good example where we have the classic strategies being employed, as opposed to this more problem-solving one. Yeah. I wish I had many more than I do, but yes, there are some. In Canada recently, I did what we call a mission there. My mother likes that because I get to say I'm a missionary. But anyway, I did a mission to Canada, and one of the issues I was looking at was the aftermath and the history of these residential schools that were put in place in Canadian communities. It left a real scar on indigenous people, not just in historical terms, but today, the manifestations and the pathologies that have developed from that experience of indigenous children being taken from their homes, their families, and away from their communities and being raised in these residential schools, often under abusive conditions. And one of the recommendations my predecessor had made about this same issue years ago was to establish a national inquiry or commission to address those issues. That was a recommendation others had made as well within Canada. And so that happened. A commission was established, and it's looking at these issues. There's suggestions for reparation. There's a whole set of dynamics that are coming up, but it's very, very locally focused. When I went back to Canada, the government was sort of pulling back from the process. I made a series of recommendations very much linked to the proposals being made by members of that commission that had been established by Aboriginal people themselves in Canada to strengthen that process, again, with a very, very much a problem-solving focus. And at least the recommendation for continuing the commission, whereas the Canadian government was going to discontinue funding, were accepted, and so that process has been continued and I think strengthened. But again, it's a very much a localized problem-solving one. And so what we see is the advocates involved in this very issue. It's not that they've given up on international mechanisms and institutions, but their proposals to international mechanisms and institutions have very much been redirected towards these local processes. And the very people that are engaged internationally are engaged locally to promote this problem-solving effort. And there are others, but anyway, that's a recent one. Ah, you picked up on that. Yeah. Right. Yeah. Okay. Thanks. As to the first issue, my experience mostly is with in the particular context of indigenous peoples, and the representational issue is particularly touchy because, by their very nature, indigenous peoples are organic communities with their own systems of governance that are rooted in history and tradition and have a political character, and they're not simply characterized or can be characterized as NGOs. So the question of who speaks for them, an agency, becomes very much bound up in the issue of representation and legitimacy of representation. What we see as to the indigenous rights movement is it is made up of advocates of indigenous peoples, meaning a number of indigenous leaders who are from indigenous communities, who represent indigenous communities, but also indigenous individuals who are part of organizations that advocate for indigenous peoples more generally, but don't represent necessarily any or aren't leaders in their own right. So, and then in addition to that, NGOs that aren't indigenous but address indigenous issues like Survival International out of London and others. So it's a very complicated thing. What I do know is that many indigenous people or peoples don't even know that these individuals exist advocating for their rights. Don't even know about the UN system, the human rights system at all. In my missions, in my trips to Africa, for example, I've been, I don't know how many times I've been in very remote areas, and I'll start talking about the UN system, indigenous peoples, and no one knows what I'm talking about. No, what is the UN? What the indigenous peoples? What does that mean? Oh, you're indigenous people. Oh, what? We're what? We're people. It's so so there's always this question in my mind. I was recently in Peru, and I went to a community designated a community in recently contacted. The indigenous people in isolation have been contacted and recently contacted, and I actually reached one. It was very, very, very deep in the Amazon, and I was very reluctant to take that initiative, but ultimately I decided to because I had heard that some had actually, were really wanting for someone to talk to them. I had to get special permission from the government because you're not supposed to go out there. You're not supposed to have any contact, but I got special permission, and they had already had some contacted, so I went there, and they I don't think it's too strong a word to say that they basically held me hostage for a while because they didn't want me to leave. They said, look, you go and you're not come back. We have all these problems that we want you to address, and you have to commit to addressing them, and we want to be heard. This is what they were telling me. This isn't what I was hearing in Geneva or here in the States. That's not what I'm hearing. What I'm hearing from the NGOs is you can't go and talk to them because they're an initial contact only. But what I heard from them is that they want to be heard and they can speak for their rights. Very complicated situations. And as to the U.S. cooperation, well, maybe it's a distinction, maybe it's not, but I was not nominated, or my candidacy was not promoted by the United States government. Now, that was under a different administration. In fact, that people think that helped me get the get the nomination. I did a mission to the U.S. and there's a lot of good cooperation with the government as to that. The difficulty I've had, and I've said this to the people in the government, is my communications are always through Geneva. That's the protocol, through the U.S. representation in Geneva. And to get that to filter down to where it needs to go it doesn't seem to happen. I was in a meeting. I was invited by the Justice Department to a meeting about strengthening indigenous justice systems. The Undersecretary of Interior was there, who heads the Bureau of Indian Affairs, several others, and I just issued my report on the United States, and these people who deal with Indian issues, Indian affairs, didn't know about my report. The very people so there's a disconnect there. But I don't think it's unique to my mandate, but it's something that I really want to address. It's not the case in other countries. I mean, when I'm dealing with Canada, I mean, all the Aboriginal Affairs people are right there with Foreign Affairs people, the same in other countries. But there's something about the U.S. bureaucracy that makes that difficult. Yeah.
Saying that's worth a report. Thank you very much for coming to talk to us. I was curious about your recommendation that there's more of a problem-solving effort at the local level. And I wonder if you've experienced, going back to the question about best practices, if you've experienced sort of a capture of local human rights organizations who've gotten used or maybe acculturated to making very positional arguments about these are the strict norms of human rights standards, and almost playing defense against others who would accuse them if they suddenly entered into negotiations with the government or tried to be problem-solving, tried to be practical, that they're selling out.
Yeah, oh, absolutely.
So how do you convince an entire movement of the legitimacy of your model, that sort of first you articulate the standards, then you become problem-solving, and that, or is it something where you're suggesting there needs to be a whole new set of players? So there's the purist types, and then there's the problem solver types, and they're different organizations.
Right. Let's say both. I mean, how do you convince? I think I'm trying to do it right now. I mean, I look at in the room, and I think I'm looking to people who are human rights advocates and will be players if they're not already in the field. And I think it's raising it and talking about it. Yes, I think we need a new cadre, but I don't mean necessarily new organizations. I think the organizations that exist can need to adapt, and perhaps new organizations as well with technical capacity, different kinds of capacity to address problems. There's this whole notion of free, prior, informed consent, and consultation with indigenous peoples. There's a whole industry now about it. People have go and give seminars all over the world within the UN system. I'm asked to do it. And I swear to God, it's the same PowerPoint. They have the same PowerPoint. Free, prior, informed consent. What is free? You're free. Prior means before. But I mean, what does that have to do with the negotiating over a hydroelectric company about a dam on a territory? I mean, it has almost nothing to do with it. So we have to break through that. We're staying away from getting our hands dirty from the real problem, and actually move in there and develop that and draw upon that technical capacity that's needed to address these problems. And it's not just indigenous issues. You take women's issues. It's not just about stopping violent husbands from beating their wives, putting them in jail. It's about addressing the systemic issues, the systemic problems that create those conditions. And that requires a lot of knowledge, a lot of thinking, and a lot of real targeted action. And so we're talking about the range of different human rights issues that require that kind. And I'm not saying forget the international mechanisms. No, I'm trying to draw the international mechanisms into this kind of action. And I have these conversations with people within the UN agencies. What are you doing? I ask them. I mean, you're having another seminar and another PowerPoint? What is this? This is the kind of thing the UN system should be engaged in. This is the kind of thing I think the donor community, Austrian government, should be supporting, and they probably do to some extent. But these donor communities are dumping a lot of money, putting a lot of money into human rights, and that's what I'm trying to say. I mean, yeah, maybe it requires a new set of actors. Okay.
Hi, my name is Anaya. I'm from the Indigenous Republic of Mexico, and last year
I've seen you someplace. Yeah.
I was studying around Paris, and there was an option in the private sector, private option of both teaching and maths as well as engineering and CMS, as well as another one in Stanford that also has it. So my question has to do with a local kind of regional implementation. As you're saying that you still may see from the top of the Constitution trying to get these mandates passed in diplomacy, but nobody on the bottom actually knows what's happening, and their actual options I'm curious to seek out. What is your suggestion on how
Well, I was Hemis this summer, I don't know if you know, at the invitation of your governor to talk about these things. And so, I can't fully reveal the kind of communications I've had with different actors involved in these issues, but it's something, that I've taken up. And with regard to the sale of these sacred objects by the auction house in Paris, that's a complex issue because it involves two governments, potential responsibility by two governments, the United States and French, and it involves transnational transnational business transactions and actors that have their presence or in different jurisdictions, and so it is by its very nature a transnational problem, but with very local, fundamentally local dimensions. And that's where the hurt is felt. That's where the injury is inflicted at the very local level. So this is precisely the situation where you do need the international system to be able to engage in these issues in a very problem-solving oriented way, with the capacity to be able to address these complex issues and come up with solutions. This is not an easy problem. What is the responsibility of the French government? What is the with regard to the importation of these objects? What really is the responsibility of the companies? Legal under French law, under U.S. law? What international standards or laws apply here? What should they be? What are the protocols that should be put in place? We've been able to sort of raise the issue, various people in concern, and even denounce this in terms of a violation. But how do you fix it? Specifically, that requires some real, very specific, careful engagement on the part of all concerned. And I'm sorry, but there's nothing really in place to do that. And that's what I'm calling for, the kind of mechanisms that can address these complex issues. So thank you very much. Sure.